Good afternoon, gang. Appreciate everyone's interest and attention. I'm joined by my Chief Deputy, Lori Torres, joined by Assistant Chief Deputy Blake Lanning, and by my Legislative Director, Aaron Tuttle. I'm Todd Rokita, the Attorney General, and hello everyone again. Thank you for being here. For 43 years, Indiana's Minority and Business Enterprise Program has done something fundamentally un-American and fundamentally unconstitutional. It told Hoosiers that the color of their skin or their gender matters more than the merit when competing for state contracts. That ends today. Indiana is returning to a colorblind approach to government contracting, one in which merit, not race, not sex, determines who wins in business in this state. I have issued a formal advisory opinion. It's one of our more detailed ones at 40-some pages. It declares the race and sex-based components of the Diversity Business Enterprise Program, DBE, as the state calls it, is unconstitutional under the Equal Protection Clause of the U.S. Constitution's 14th Amendment. I'm pleased to see that Governor Braun has already acted on this advice and announced that the state will end its race and sex-based spending goals in state contracts. Our opinion also confirms the governor has authority to decline to administer a statute in these particular circumstances. An unusual step, but one firmly supported by the law. I also note that the General Assembly has had multiple opportunities to repeal this unlawful program, including Senate Bill 289 in 2025, but failed to act. Several opportunities since the Supreme Court decision making this program and these practices unconstitutional. In fact, even after Students for Fair Admission's decision in 2023, lawmakers amended the DBE statute no less than 4 times. They made changes such as updating references from chairman, quote unquote, to chairperson, but did nothing to end the core unlawful discrimination against Hoosiers. This opinion that we're releasing today is precisely what voters demanded in 2024, an Attorney General willing to end discrimination and restore fairness under the law. And that's exactly what we've been doing and will continue to do. So how did this unconstitutional program work? For more than 4 decades, state government certified businesses as minority-owned, quote unquote, or women-owned, quote unquote, based solely on the race or sex of the owners. It then imposed mandatory numerical spending goals on nearly every state contract, dictating exactly how much money had to go to these preferred firms. Bidders were required to submit detailed subcontractor plans proving they would meet those racial and gender quotas or demonstrate good cause or good faith efforts to find those subcontractors. Failure to comply could result in rejected bids, withheld payments, terminated contracts, or debarment from future work. In short, the government put its thumb on the scale against any business not owned by someone in the state's favored racial or gender categories. This wasn't just special treatment, it was discrimination. Why is it unconstitutional? This program, as I just outlined, doesn't survive this U.S. Supreme Court's highest level of review. It relies on explicit racial and sexual classifications in state contracting, the very thing the Equal Protection Clause was written to prohibit. Our Constitution demands colorblind government, treating every Hoosier and every business without regard to race or sex. Our opinion draws directly from the U.S. Supreme Court's landmark decision, Students for Fair Admissions, which made clear that government may not distribute opportunities on the basis of race. This decision is probably the most significant Supreme Court decision on equal protection since Brown versus the Board of Education. What we're doing today to give effect to that decision is on par with many other big fights the country has had in the past on discrimination, from desegregating the South to getting rid of Jim Crow to passing the 19th Amendment to ensuring women have equal right to vote. What are the harms caused by this? Even if it's unconstitutional, why should we care? Discrimination based on race is a Pandora's box. Once opened, it harms everyone. Those it discriminates against, those it claims to help, and society at large through division and resentment. As Justice Clarence Thomas has observed, such preferences inflict a stigmatic harm by suggesting that minority business owners cannot compete on equal footing, a condescending message that undermines true equality. And it's an opinion I fully agree with. As we were reminded this week during Indiana Black Expo, our state is home to many vibrant and dynamic Black-owned businesses. I support them all. It is an insult to those businesses and everyone else to suggest they need preferred treatment to compete effectively for state contracts. And I'm not going to treat them or anyone else that way. We believe in a colorblind opportunity. Every business should succeed or fail on their merits. This opinion represents our latest aggressive, sustained campaign to root out illegal DEI across Indiana government. We have required anti-DEI certifications in all new state contracts with False Claims Act penalties for violators. We have blocked contracts with law firms that engage in discriminatory DEI practices from getting work with our office or any of the state agencies. We have launched investigations into DEI programs at private universities, including Notre Dame, Butler, and DePauw. Those investigations are ongoing. We've supported INDOT's, Indiana Department of Transportation's efforts to waive unconstitutional federal requirements, and we've led multi-state efforts to eliminate DEI mandates from federal contracting. So what happens next? Existing contracts will still be honored. Existing contracts with the state of Indiana will still be honored, but going forward, Indiana is now fully committed to colorblind contracting. Veterans' preferences remain fully intact, as they are not based on race or sex and do not fall under the Students for Fair Admissions rubric. We will be advising the Indiana Department of Administration on a smooth, lawful transition, and we'll continue working with legislators to repeal the underlying statutes. So with that, my staff and I are happy to answer your questions.
What would you say to folks who believe that this is a legal justification for a philosophical belief?
Well, I'm not a philosopher, but it is unconstitutional. I mean, that's the bottom line. Whatever your philosophies are. Excuse me?
So ideology is not driving this?
Well, the Supreme Court's decision in fair admissions is driving this, right? And it's unconstitutional to discriminate on race and sex. I mean, that's the bottom line. I completely agree with that conclusion, by the way.
Does that mean you're working to get women equal pay?
Does that mean that we're working to get women equal pay? I don't find the current pay structure unconstitutional, nor does the Supreme Court. So as the attorney for the state of Indiana, you know, if the Supreme Court, the Indiana Supreme Court decides something is unconstitutional and it applies to state contracting, we'll certainly be looking at that.
Mr. Attorney General,
And then,
can you give concrete examples of where these preferences hurt businesses that could have been awarded a state contract? For example, as a result of these preferences being in place, a project went over budget, or a project that had this deadline went way past that deadline. Can you give some examples of businesses?
well, I know that in studies here at the state level and beyond, in other states, they found that this kind of program has cost taxpayers more money to implement, so on and so forth. But that's not the basis for my decision, my opinion here. The opinion here relies on the fact that it's a violation of the Equal Protection Clause with the 14th Amendment to have a program do this, regardless of cost or not. So if that's your question, you know, it's irrelevant to the decision here. It's unconstitutional to discriminate. These programs, by their definition, and certainly in their practice, discriminate, and so they can't anymore. That's the point. And let me have some of my other staff answer this if they'd like. Then we'll go. We're not going anywhere. So
I'll be happy to jump in there. My name's Lori Torres. I'm the Chief Deputy for Attorney General Todd Rokita. Some years back, I was General Counsel for Indiana Department of Transportation. And in fact, this was a standard operating procedure. The program there is called DBE, Disadvantaged Business Enterprise. It's under the Federal Highway. We helped NDOT this year write an exception to Federal Highway and the Federal Department of Transportation so that they could not follow this program any longer. NDOT has studies about what this costs in terms of, to your question, but again, this is not the basis of the opinion. And so I do know that, in fact, this is pervasive in government. We get sort of acclimated to this, like, oh, it's a minority business program. That sounds really good. I don't think any of the jobs that I've had a preference because I'm a woman. I wouldn't want one. I think I've gotten my positions as Inspector General, Deputy Commissioner of NDOT, Chief Deputy here on my merit. And so I worked very hard along with my co-workers here on this opinion. We've worked on it literally for several years. We worked on it through multiple administrations. So credit to the Braun administration who brought this to fruition today.
let me go to Emily first.
I'm going to ask the state, when they put this statute in place in the 80s, they said they did disparity studies that found discrimination. Do you think those disparity studies and what they found no longer apply at this point 40 years later?
I'm going to have Blake Lanning answer that one.
Yeah, it's a good question. I think, and we analyzed that question extensively in the opinion. I think the bottom line is Supreme Court has said the only way that a racial discrimination of any kind, a racial classification, could ever possibly be justified is if the government action to engage in the discrimination is being done to remedy specific instances of past discrimination that the government engaged in. So then the question is, does a statistical disparity study demonstrate that there has been past instances of discrimination by the government against individual businesses that would benefit from the program? And the short answer is no, absolutely not. That's not what a statistical disparity does. And if you read the DBE statute doesn't even pretend that that's what the statistical disparity is supposed to be doing. The disparity study that IDOA has done for years looks at countless different contracting decisions made by countless different decision makers, both private and public, across the entire state in various different industries, aggregates that all, combines that all, and then pops out essentially 3 or 4 percentage numbers that say, well, there's a very high level disparity between the number of minority-owned businesses in the state and the number of minority-owned businesses or women-owned businesses that contract with the state government. And that, like we say in the opinion, I think the exact line is that type of conclusion in a disparity study is light years away, absolute light years away from what the Supreme Court would say is an actual demonstration that there has been past discrimination that could ever possibly justify racial discrimination by the government. Because it's worth remembering, at the end of the day, what we're talking about is to satisfy the Supreme Court's test, the government has to show a compelling interest in why it would discriminate. And that is completely justified because what we're talking about is the state of Indiana, your government, deliberately choosing, I'm going to treat one person differently than another person based on race. And I think all of us from a young age have been taught that is fundamentally inconsistent with the Constitution, fundamentally inconsistent with who we are as a people. And that's why it happens in only very rare cases. And the disparity study that IDOA has performed simply cannot be the foundation for that type of really dramatic and unfair action that the government would take if the program were to continue.
Mr. Rikita, it's very difficult for a business to prove.
1 second, please. I'm sorry. Did you have something then?
Has anyone brought suit over this in the last 4 years saying they've been harmed by the state's practice?
Not that I'm aware of. Next.
It's very difficult for a business to prove that they were passed over as a subcontractor or a contractor based on their race or sex. But one thing it's much easier to prove is whether or not a contractor or the state actually made the effort of giving them an opportunity. What would you say to businesses who say this essentially takes away a guardrail that prevents discrimination?
Well, first of all, that's not the standard. Again, the Supreme Court has said, only in very rare demonstrated circumstances is it okay to discriminate, right? And to the extent that a business is going to complain, hey, I don't have an opportunity now with the state, I want to hear more about that. That's not based on race and not based on gender. I want to hear how our contracting practices are so bad. And when I say ours, I should say the governor's agency. Contracting practices and guidelines and procedures, however you want to describe it, are so bad that a business can't participate, because that's your question. And I don't see that that's the case. I think it's pretty open. I don't know if Lori has any more comment on that or not.
No.
Okay. Yes. Okay.
So if the goal is to prevent.
And then you.
If the goal is to prevent discrimination, who is it that you feel, or that in your opinion is being discriminated against should this program stay in place?
Well, by definition of the program, Caucasian people have a less of an opportunity, right? Because you're giving preferential treatment to women or based on gender or race. So it has to be an even playing field. That's what our opinion's saying. Does that answer your question?
Yeah.
Can I add to that?
Yeah.
I would also just note, and this is I know it's a really long opinion, so we're not expecting that obviously everyone's going to wade through it, but I would encourage folks to read it. Like, there's a lot of detail that answers a lot of the questions you're getting at. We address that too in the opinion. I think one of the problems that the opinion identifies with the DBE statute, there's many, many problems. One of the problems with the DBE statute is how it defines minority group, right? If you read the DBE statute, it says a minority group, the groups that can be preferenced by the program, consist of African Americans, Hispanic Americans, Asian Americans. Those are the groups that are singled out by the statute. But if you look at other statutes, for example, the federal government, the Small Business Administration, for years has had programs for socially and economically disadvantaged groups. That program defines minority differently to also include Middle Eastern individuals or Pacific Islanders. So one of the critiques that the Supreme Court made in Students for Fair Admission of what Harvard was doing in that case was Harvard was using these really vague, broad, and ill-defined racial categories. And that made it so that the program clearly was not designed to address actual instances of discrimination. You can say the exact same thing here, where the state has defined who are the benefited minority groups in a really loose and broad way. And also, I would note, in a way that doesn't just exclude Caucasian individuals, right? Under the definition in the statute, a Pacific Islander could not benefit from the MeBe-Weebie program. Under the statute, someone from the Middle East who doesn't fall under, Asian classification or Hispanic classification couldn't benefit from the program. So again, it's not just I think it's way too oversimplified to say, oh, we're talking about white people versus everybody else. It's an inherently fraud exercise for the government ever to get into the business of kind of defining people and slapping race labels on them. But the way the DBE statute does it in particular is very crude and draws just really bad lines that don't make any sense and again, fundamentally have no relation to past discrimination.
Can you explain, Mr. Attorney General, could you talk about efforts to work with lawmakers to repeal the underlying statute? And do you also anticipate challenges to this move, such as, say, from groups like the ACLU?
Oh, I'm not going to pretend to know what other groups are going to do. We're prepared for anything and everything, and we'll win. They can get in line. There's a lot of people that sue the state every day. We'll win this one. It's easy. And then I'll have Aaron Tuttle, our legislative director, speak in more detail to our efforts with the General Assembly over the last couple years. But they've been proactive and they've been detailed. And the General Assembly members specifically said, we don't want to touch this. So that doesn't make the law any better. It doesn't make the law any more constitutional. And it gives the governor, as we say in our opinion, the right to ignore it. And he did, like Lori said, he did the right thing today. Aaron, excuse me.
Thank you. Hi, Erin Tuttle. I'm the legislative director for Attorney General Todd Rokita. You know, there is a supermajority here in the General Assembly, but there are a lot of different voices and opinions within that supermajority. And I mean, my hope is that with this opinion, with the information in the opinion, it will educate our members of the General Assembly in a way that will help them understand that they can't do nothing. It's discrimination, and it should be dealt with by the General Assembly in the appropriate way. Is there something specific?
Have they agreed to take on this issue next session? Have you heard from Republican leadership at this time regarding this move?
I have not, but I hope to. And we're happy to help them with that, with drafting and everything like that.
Can you explain why you believe the governor has the authority to take this action if the statute is still in place?
Yeah. I'll let an attorney speak to that.
What was the question? I couldn't hear you.
Can you explain why you believe the governor has the authority to take this action while the statute is still in place?
Sure. And again, so the question was, explain why we believe the governor has the authority to take action to ignore the statute. Is that it?
Take this action.
To take this action. So that was the question. Again, please read the opinion because it gets in more detail on this. And the fact of the matter is, like, this is illegal. This is unconstitutional. And so this was a difficult part of the opinion. I mean, we are respectful of what the General Assembly passes in terms of what they declare is the law. You've probably already read some comments criticizing this part of the opinion this morning. And so it was very deliberate and very careful when we went through this in terms of he has constitutional authority to take care that the laws are executed here, and we believe that based upon constitutional law, that his authority is to take care that constitutional law is followed here. I'll let Blake elaborate if there's anything else that he wants to talk about on this topic.
I would just add, I guess, a couple points. One, to emphasize what Lori's saying, that we fully recognize, and I think part of the reason why this opinion is as long and detailed as it is because we fully recognize that it is very unusual and should always be a very rare step for the governor or our office or any other executive branch official to, no longer implement a statute that is still on the books. That being said, there is precedent for doing that. There's guidance. We looked a lot at the federal level, right? There have been points in history where the president of the United States has declined to follow a statute. And if you read, opinions from the Department of Justice, there are certain principles that executive branch officers apply to reach that conclusion. And in a nutshell, what it boils down to is it's not just a conclusion based on or an action based on, we think the law is bad or we think it's, unconstitutional. As the opinion says, the statute is not just unconstitutional, it's very clearly unconstitutional. Like if we were in court trying to defend this, there is no straight-faced argument to defend the state engaging in this type of discrimination. And so I think in those rare circumstances, that's where we say, okay, the governor does have kind of the unique authority and duty under his constitutional oath to take a step like this.
And then just let me add my answer to the question, not only as the Attorney General in the executive branch, but as someone who served in a legislative body as a congressman for 8 years. I take following the law that lawmakers enact as a very serious constitutional duty. There's a duty not to ignore the law. So this is not a situation that gives me or the governor or any other executive branch office holder like some carte blanche to say, oh, I don't like that law, so we're not going to follow it. I got an oath to the Constitution. It's not one of these things where, I swore an oath to the Constitution to take care, and I don't like the speed limit, so I'm not going to follow it. No. There was a very specific intervening cause here called the United States Supreme Court in a specific case called Students for Fair Admission that declared this type of practice, these types of programs, unconstitutional. We advise the General Assembly very directly, very often, that they had an unconstitutional and therefore illegal law on their books. They have done nothing. The governor and I have done something today.
We have to get the AG to his next meeting.
One more. Anybody?
And again, just to clarify, this is not a legally binding order. The governor's just choosing to take action based on your opinion.
My opinion has weight. It's not legally binding in court, maybe, but we don't need it legally binding in court because the court's already spoken. So the governor and his agencies asked for my advice. We gave it. They're taking my advice. Thank you.